On the 28th of June, the Public Rights of Way and Greens Committee will consider 2 applications to register Stoke Lodge as a town or village green. That's a legal test. You have to show that there have been 20 years of as-of-right use for lawful sports and pastimes. And as-of-right has a technical meaning, not by right, but as if you had a right. This is a summary of the outcome of a long and complicated process, key parts of which are outlined on the screen here. To cut a long story short, the inspector produced a report in March 2023 that said there were 2 main reasons why the land should not be registered, which we'll explain in a minute. But his report also misquoted and misrepresented some of the evidence we submitted, and it ignored some key issues altogether. All parties were offered the opportunity to comment on his report. And because his failure to deal with our evidence was so fundamental, we handed our full submissions directly to the committee so they could see what was wrong with the inspector's report. The inspector then reviewed those comments and wrote a note in which he admits that he was wrong on some issues and might have misunderstood the key case that he was relying on. He also says that it's up to the committee to weigh the facts for themselves, and that it's open to them to conclude that the legal test for registration is met. It's hugely frustrating that after a process that has taken nearly 5 years, the inspector's report is so fatally flawed that it can't be used as the basis for a lawful decision. It's doubly shocking because the council and Cottam School, who objected to the applications, didn't put in any evidence at all. They just asked the inspector to ignore ours. Part of the problem is that the Commons Registration Authority, which runs the process, did not follow its own agreed procedure by holding a public inquiry. It didn't even send our 166 witness statements to the inspector, so he never saw them at all. If the proper process had been followed, some of these errors would not have been made. But right at the end, the inspector has conceded that the key decisions must be taken by the committee having actually looked at the evidence. We're confident that as they look at the separate issues involved, they will see where the inspector went wrong. Obviously, there's lots that we can't cover here, so for more information, visit our blog. I'm going to very briefly explain the 2 main issues the inspector has focused on. First, it's about 2 signs that were put up by Avon County Council in the mid-1980s. Our evidence showed that Avon County Council accepted informal use of playing fields. The inspector accepted that our documents prove that from January 1990, Avon County Council did not object to informal use. But he thought the signs override this, even though everyone was using the land anyway. We provided evidence about Cottam School's actions, showing that the school never objected to informal use and in fact acknowledged it in their annual contracts with the University of Bristol. We've got solid evidence of more than 20 years' use of the land, with the council and the school never objecting. But the inspector said the only thing that mattered was the signs, because of a Court of Appeal decision called Winterburn. He now says he may have misinterpreted the Winterburn decision. We'll come back to that in a minute. The other issue is that because there was a public inquiry in 2016 about a previous application for village green status, the inspector thinks everyone should have thought that the council was objecting to informal use after that. But here's where he's still ignoring the evidence. Firstly, after 2011, when Cottam School got its lease to use the playing fields, the council didn't have power either under the lease or under the law to control the use of the land at all. He's clearly legally wrong on this, and he's ignored the fact that the council spent the next 2 years defending the decision to grant TVG status, which if anything sends a clear message that ongoing use was absolutely fine. And remember that the school took away the old Avon signs in July 2018 and put up its own signs with the express purpose of restricting informal use. And there's a smoking gun. We know that the school and the council were discussing making a landowner statement to end as-of-right use in 2018, and Bristol City Council took legal advice and decided not to do that. If you want to know more about this, visit our blog. But this shows that the school and the council and all their lawyers thought as-of-right use was still going on in 2018, and that BCC decided not to end that use. either because it didn't want to, or because it thought use had been going on for more than 20 years and didn't want to trigger another TVG application. Either way, it tells you all you need to know. The inspector is wrong and the council and the school both know it. In his final note, the inspector changed his position and floated the idea that a We Love Stoke Lodge poster in summer 2018 showed that there were tensions about Cotham's fence proposal. But that poster wasn't even in evidence. He's imagining what he thinks it might have said, at the same time as ignoring the actual evidence before him. This conclusion is just nonsense. Coming back to the Winterburn case, the inspector has now said that if he's wrong that the signs override everything, then the land should be registered on the basis that all our evidence shows the school and the council acquiescing in ongoing use for over 20 years. And he is wrong, because the case itself says that the question isn't just whether there are signs, it's about whether the landowner has clearly indicated a continuing objection to informal use. And he's accepted our evidence that from January 1990 there was no such objection. But it's even simpler than that. There have to be enough signs, and the court in Winterburn said that 2 signs in a car park with a single entrance were enough to restrict use of the car park. But you can see here, that car park was about 1/10 of the size of a football pitch. There it is, to scale, mapped onto Stoke Lodge. It had 2 signs and 1 entrance. In December 2016, the committee decided to register the land, saying that Stoke Lodge is very different on the facts from the Winterburn car park. The High Court said that wasn't controversial. Stoke Lodge is 200 times bigger and has loads of entrances and back gates onto the field, and just 2 old signs put up by a council that was abolished in 1996 and was on record as not objecting to use anyway. If the committee now agrees that 2 signs are not enough, then the land should be registered. So what's next? Cotham School is asking the committee just to endorse the report despite all its obvious mistakes and failings. That, of course, would only lead to further litigation, which would be a huge waste of taxpayers' money. The council, on the other hand, has endorsed the inspector's final note. It says these are matters of fact for the committee to decide, based on the evidence and submissions that are before them. Our view is that it would be clearly unlawful for the committee to accept the report as a whole. The only option is to consider the separate issues and to weigh all the evidence, which the inspector has failed to do. And when the committee members look at our submissions, we're confident they will decide to register Stoke Lodge as a TVG, protecting recreational use for Bristolians of all ages and stages of life, as well as school and club use, for generations to come.